Hello, friends and clients of W Immigration Law Group. I am Jennifer Walker-Gate, board-certified immigration attorney in Austin, Texas. And I am here today in this video to talk about whether a person can be deported or not while their I-601A waiver is pending. I have been getting so many questions from lots and lots of clients about this issue. Lots of clients who have waivers pending and who are concerned about the current administration's increased enforcement activity and who they're going to be targeting. And people want to understand what will happen to their case if there is an ICE encounter while their waiver is pending. So that's what we're going to be talking about today, hopefully putting some anxiety to rest. Before I get into the substance of today's topic, please take a moment and subscribe to our YouTube channel. We're going to be providing lots of updates, lots of factual information for the immigrant community in Central Texas and across the United States throughout the Trump administration. And it is really more important than ever now to really have trustworthy and reliable sources of information. There is so much fear-mongering happening online, even unintentionally. A lot of people are seeing enforcement actions that are several years old and thinking it's happening right now. They're seeing regular law enforcement activity and thinking that it's ICE enforcement, and all of that stuff is spreading like wildfire online. And what we want is for everyone to feel calm, well-informed, clear, and able to act and think strategically. That is not possible if we're in panic mode. So please do subscribe to our channel, share our channel with loved ones and friends who can benefit from this information, and contact us if you need help. We will be happy to assess your case. We will give you a really honest assessment of what is likely to happen if you do have an ICE encounter, whether it is worth your money and time to try to defend yourself against deportation or not, how to best spend your resources, how to set up, an emergency plan. And in fact, we have a safety guide that we are offering now. If you email us at info@jail.law and ask for our safety guide, we will happily send that to you in English or Spanish so that you have a well-designed, kind of spelled out checklist of things to go through to put yourself and your family in the best position to be safe and secure for the long term. All right, so with that, let's get into today's topic. The question is, can you be arrested, detained, deported while your I-601A is pending? Okay, we have a lot of people in some stage of the I-130, I-601A, DS-260 process, which is common for a lot of folks who enter the United States without permission and then want to get their residence status. They need a waiver, they need to leave the US and come back after visiting a consulate abroad because they entered without permission, but they have a way to get the residency if they go through all of those processes. So the short answer is yes. If you are waiting for your I-601A to be approved, you can be deported, yes. However, this is a really important point. Let's talk about the likelihood of that actually happening, and let's talk about steps you can take if that does happen to minimize disruption to your case, to avoid actual deportation, to continue with your waiver, to continue toward your resident status. Because once you have that resident status, then the risk of things like this happening goes way down. So we want as many of our community members as possible to successfully reach that goal, getting their green card. And we want that process to be as smooth and disruption-free and as fast as possible. So we have lots of experience helping people manage all of these different moving pieces, including when there's an arrest, a detention, and deportation proceedings. Okay. So if you're eligible to file an I-601A in the first place, we can presume that that means you don't currently have lawful status in the United States. Okay. If you're filing an I-601A, it's because you probably entered without permission, or maybe you entered with an overstay, that visa. And that is true for people whose petitioner is not a US citizen. If your petitioner is a lawful permanent resident and you entered with permission and overstayed, you still have to go through that immigrant visa process with a waiver, okay? So in those cases, you can be detained by ICE because you don't have current lawful status. at this time, and it's been true in many, many presidential administrations, that if you don't have lawful status in the United States, you are at risk of being detained by ICE. Under the Biden administration, the president was very clear that his priority was not going after people who weren't a criminal threat. This current president wants to pretend like every single immigrant in the world is a criminal. And so they are talking more about detaining people who just don't have legal status. So it could happen. You could be pulled over in a car. That's the most common way we see people getting picked up. Let's say you have an I-601A pending and you get pulled over and you don't have a driver's license and you get taken to jail and then ICE picks you up. That can happen. They're going to detain you and probably put you in removal proceeding. What we've seen over the last week or so is that people in that situation, if they don't have a serious criminal record, which you wouldn't be eligible for the I-601A in the first place if you had a serious criminal record. So that's important to note. So if you have this pending waiver, it means you don't have a serious criminal record. And what we've seen is that those folks are getting released. But you can be put in removal proceedings. You can be put in detention and you can be put into deportation proceedings. Hopefully you don't have any past arrest for any kind of assault or shoplifting or anything like that. Even if those were dismissed under the new Lake and Riley Act, those arrests make you subject to mandatory detention, and that can really throw a wrench in everything. But hopefully you don't have anything like that and you get released, okay? That is the ideal situation in that situation, because getting detained by immigration and placed in deportation proceedings does not automatically mean that you will get deported. That's not what it means. A detention by ICE does not often result in someone just scooping you up and immediately throwing you back to your home country. Usually there's an opportunity for people to get a bond and get out of detention, or a parole from ICE to get out of detention and pursue their protection against deportation from outside of detention. So that's what we would hope to see. If you are placed in removal proceedings, there's a number of things that can happen, okay? This includes while your I-601A is pending or any other time. If you're placed in removal proceedings and deportation proceedings after a detention by ICE, you might get an order of deportation from the judge. You might be someone who just got arrested for something really bad, and they might just be like, you know what, you're out. And if that happens, you're going to have to file another waiver. You would need a new assessment to see if you're eligible for your permanent resident status anymore. It's possible that you might be, but it's possible you might not. So you're going to need a new assessment if you get an order of removal after being put in deportation proceedings. However, a lot of people get what's called an order of voluntary departure. That is not the same as an order of deportation, and it doesn't require an additional waiver or additional steps to come back to the United States if you leave under an order of voluntary departure. Now, an I-601A for somebody who leaves the United States is not going to be valid anymore. You're going to have to do a different kind of waiver, and there's going to be more years added onto your process if that happens. But again, the point is that just getting picked up, detained, and placed in deportation proceedings does not mean that you will automatically get deported. The other thing that you can hopefully do if this happens, and this is what we try to do for our clients, is get what's called administrative closure of your deportation case. Ask the judge to administratively close the case so that you can continue to pursue your waiver. And then when your waiver is approved, you ask the judge to reopen and then terminate the case or dismiss the case, get rid of the case. So I like to compare it to administrative closure is like putting your deportation case to sleep, and then termination is like fully killing it, like the vampire, right? So administrative closure, the vampire goes into a coma, then terminate it, kill it all the way dead, and you don't have a deportation, you don't have deportation proceedings. You can continue with your immigrant visa process at the consulate and not have to worry about it. You can also, instead of even asking for administrative closure of your case, you can ask for outright dismissal of your case. Now, we're going to have to see how the Trump administration courts handle these kinds of requests. Under the Trump administration previously, there was a lot of back and forth about whether judges were allowed to administratively close cases, about whether they were allowed to dismiss cases and under what circumstances, whether you had to get agreement from the ICE attorney to dismiss or administratively close a case. There was a lot of battle about that. We're beginning to see changes in that direction again with this new administration. But I will say this, in spite of all of that, it is still possible to manage a removal case and a waiver case at the same time and keep them both alive. The reason is because they both take forever. Okay. So what could happen, this is what we had happen before, is that someone gets picked up, they have their waiver pending, they get picked up, they get put in deportation proceedings. They go to court, the judge won't dismiss the case, won't administratively close the case, but they will give the person another court date to come back at a later time. Maybe they need to get an attorney in the meantime. Maybe they need some time to prepare an application to explore possible avenues of defense against deportation, etc. The immigration courts are so backed up that another hearing could be 3-4 years in the future. So by that time, there could be a new president in office with different priorities, giving different instructions to the courts, and then the court might dismiss the case. The court might administratively close the case. The court might be amenable to doing all kinds of things at that point that they weren't able to do under the prior administration. So it's crazy out there, y'all, but this is how it works. This is how it happens. It's important not to lose hope. It's important not to be too scared. If you have your I-601A pending and you have an encounter with ICE, there are rights that you have that are important to know, okay? Number one is to ask if you're under arrest. If the answer is yes, then your next answer might need to be, I would like to speak to a lawyer. If they're asking you for proof that you've been in the United States for at least 2 years, that is an indication that they may be considering expedited removal for you and they want evidence that you are entitled to fight your case. In those cases, just show them your I-601A receipt notice. Show them your I-130 receipt notice. Do what you need to do to prove your long-term status in the United States and ask for a lawyer. Eventually, they're going to let you fight your case. They're going to let you see a lawyer if you don't have serious criminal history or prior deportations. So please remember that you have rights, you have opportunities. All is not lost. All hope is not lost. We cannot let this situation take all our hope. Our families and our love for our families is stronger than all the hate. And we're going to get through this. We're going to keep people together. We're going to help families get through adversity. We're going to get to the other side of things, one way or another. It may be painful. It may be hard. It probably will be for, I know it already is for so many people. A lot of our clients are very scared and really upset at this moment, and that is fully understandable. I just don't want people to give up on their cases. I don't want people to give up on being united in their long-term security in the United States together. Email us at info@jlw.law. Get our safety guide. We'll be happy to send it to you for free. If you just send us a quick email asking for the safety guide, send us an email, call us, get on our website and schedule an appointment if you need an individualized assessment for your case. Please share this video, share our channel, take good care, and we'll see you again real soon. Bye-bye.